I turn my focus these days more toward law firm management and being a smart and productive business owner, as opposed to going back and learning those tools of my trade on the substantive areas. I keep the rest of them, but this is the stuff that really makes me tick lately. And I was with Elva in the planning of the entire series, and one of the items that came up that we thought might deserve some attention was this idea of the business and the financial relationship with your clients combined with the ethical requirements that we have as attorneys. So as we got into this, we saw that so much of what we are talking about is really guided in part by the ethical obligations, and then ultimately we're trying to see, well, how do we make a living doing this, and how do we do it in a productive way? So that's kind of a long-winded way of saying that this is kind of how we see our program today. Donald Trump meets Perry Mason. And so we're going to be weaving in and out today on ideas of business management within the confines of the California rules of professional conduct. So Elva told you a little bit about my practice, and I want to give you my perspective because that will help you understand the comments that I'm going to make. I am from a mid-sized firm in San Francisco originally. That was my first law job. I like to say my second was when I decided to start my own law firm. I'm what we would consider a small law firm, 6 to 7 lawyers. Will never be bigger than 10. We don't choose to. I have been in a management role in both firms, and the other firm was in that 20, 24 size range. We have had every issue imaginable. We've built out offices. We've had partners who have gone AWOL. We have had partners who dumped a firm in financial crisis on young lawyers who were either going to close it up or move on. It's been an interesting ride. And so what I take from that basically is how to try to practice smarter, okay? And I want Harry also to give his background because it's a little bit different than my situation, and it will give a different perspective.
Yeah, I think it is a little bit different. Alva kind of called me out immediately. Oh, hi, nice to meet you. Why are you qualified to be here? And the answer is, so almost the opposite. I work at a firm of 1,150 attorneys. I came from a firm of 3 attorneys in Marin County. And then, so at Littler, I guess what I am is a very small owner of a very large firm. But in the last, it's been really evident to see the last 5 years how the firm has been, with the economy and everything, it's been, having seen what's happened at other big firms that made very poor financial decisions, it's become very business driven. And as a shareholder, we get emails every day. And you can't open up an internet window without seeing where your numbers stand, what your statistics are. Here's where your billable hours are. Here's the percentage of your collections that you've received month to date. There's a new committee that the firm started this year, the Management Investment Client Committee or something. We call it the Break Your Kneecaps Committee. Because they come and they subject you to holdbacks if your pre-bills aren't turned in on time, and if you don't release time every Monday night by 7 o'clock, things like that. So my perspective of the business of law, where I come from a firm where we do have, we have billing coordinators and receivables managers and all that. It still boils down to, if you're the attorney and it's your client, you're going to ultimately be responsible for bringing the dollars in, making sure that contracts are entered into and agreements are entered into with the clients, in a ethical and business-like way, and ultimately the bottom line is going to fall down to you. So that's where I'm going to be coming from.
So as we get started today, we want to make sure that our comments are tuned in with our audience. So what we're trying to do is gauge first of all, I'm going to break it into 2. I'm interested in kind of big firm or solos or smaller firms, so I'm interested in that. And then also, if how long you've been practicing law, it will really help us. So are there people in the audience who are solos? Okay. So most. And then what about any other big firm lawyers? Big, I'm going to say, from 20 or over. Okay. And anyone here been practicing less than 5 years? Okay. And then anyone here over 20? Okay. So we'll try to make it as well-rounded, but keeping in mind our audience. So we're going to start. When we were preparing our presentation, we thought, well, let's start at the very beginning, because we're really talking about the management of your clients. And the first thing that's going to come into play, obviously, is the engagement agreement. And Harry's going to address this part of our program. And the only thing that I want to mention is, as we weave our way through some of the other issues, you're going to hear us coming back to the engagement agreement, because so many of the things that we're talking about in relationship between attorney or firm and client are really driven by the contract that you reach with your client. So with that, I'm going to turn this over to Harry. And do you want to come over here?
Sure. So it seemed like it was mostly solo practitioners in the crowd. Do you all have an engagement agreement that you use with your clients? That's good. I was reading one article and it went through some of the reasons. And, there was the whole idea that the person who represents themselves has a fool for a client. The old adage. But one area where almost everyone represents themselves is in negotiating whatever contract it is they have with their client, which is usually through an engagement letter. California is a state that actually, through the Business and Professions Code, requires written agreements. But in terms of reasons to use engagement letters, a lot of them require it, including California. Written contracts with our clients. We need written contract with our clients for the same reason that our clients need them with third parties, to avoid confusion and simplify enforcement, and we'll get more into that later. Absent such contracts, we'll at times find it unnecessarily difficult or even impossible to collect our fees. That's probably the most important thing. Unless we clarify who is not our client, we run the risk of being sued by those we never intended to represent, but who believe that they are our clients. And unless we clarify what we have and have not agreed to, we run the risk of being sued for matters that we never thought we undertook. So the ABA model rules actually prefer the use of engagement agreements. They don't make it mandatory unless you're working on a contingency fee basis. So that's the perspective of the whole country sees. But in California, the rules of professional conduct don't say anything about engagement agreements, but under Business and Professions Code 6147, an attorney, 6147 makes use of a written engagement agreement with the client mandatory in a contingency fee case. The contract shall be in writing and shall include statement of the contingency fee rate that the client and the attorney have agreed upon, right? A statement as to how disbursements and costs incurred in connection with the Yeah. Sorry. Anyway, this is contingency fees. What we get into with 6148 is the idea that this is where we see that engagement agreements are really mandatory. It's that where you got to use them is in any representation where it's expected that the fees incurred are going to be over $1,000. And I would hope that would be a lot of the matters that we undertake. So, what I'm actually interested in is, so in the engagement agreements that you guys use, is it something that you've specifically drafted, or can anyone just volunteer in terms of where did you get it? Did you draft it yourself? Did you find it on the internet? Did you Google it? Yeah.
I used the State Bar's model agreements and changed some things or revised them.
So what did you change?
Typically just the fees. If I'm doing a fixed fee, I add that in there instead of the hourly fee.
Okay.
And I make sure I narrow the scope of representation to what we agreed on.
Right. Do you usually do most contingent work or hourly work or other?
At the moment, mostly other. Actually, contract review and drafting tends to be a fixed fee agreement with me.
Yeah. And you raised your hand. Where did you get your agreement?
I received one from a compatriot that I've known for years. I've had one built and completely vetted by a couple of people who fit within 6148. And also a modified version for pro bono cases. And it's very specific as to the outline of the services we will render and how far we will, because it's special education law, and you can flip into the appellate area, and that changes everything dramatically.
Yeah.
So it goes only so far, and then necessitates a further agreement.
For the pro bono work that you do, how do you allocate costs?
The costs are to be paid by the client. There is the requirement of an initial retainer, but a small one for costs. And then there are provisions within it for the engagement of other professionals, neuropsychologists, that sort of thing. It specifically states this does not come within this agreement, and they are yours to procure and pay.
One of the things that these 6147, 6748, 6148 mention is that these apply to agreements that are not covered by 6146. And does anyone know, are you familiar with 6146? Are there any personal injury lawyers in the crowd? That there is a specific statute that addresses solely the fees that can be charged in a personal injury case against a healthcare provider. And it basically, lays out that the first $500,000, it can only be 30%, 25% of every $50,000 thereafter. So as you're reading through the handouts and you look at the requirements here, when it's referring to any contract not covered by 6146, that's what 6146 is talking about. So pragmatically speaking, there's a study done that basically decided that between 2008 and 2011, I think Zurich Insurance did the study, but 16% of all legal malpractice claims were the result of poor communication between lawyer and client. I actually find that very difficult to believe. I think the number would be a lot higher. But the whole idea being, when they broke these claims down, nobody spelled out what the relationship was going to be at the very beginning of the representation. So, as we look to our engagement agreements, what should they include? First and foremost, to identify the client. Who do you represent? I don't know, has anyone gotten into a gray area here? Because we represent, Littler Mendelson does all employment law, so we'll represent companies, but then we'll end up having managers or shareholders thinking that we represent them as well. So has anyone gotten into a gray area in terms of an agreement as to who you actually represent?
Yeah.
Like, give an example. Was it like a company issue?
I mean, you get it. I've done that too, where you represent the company, and then you also have the employees, and you're going to their depositions and things as who you represent.
Right.
And I've also had where just a client comes to you and wants you to, a lot of times like with business formation issues, they come to you and they want you to help them form a business, and the question becomes, well, who am I representing? Am I representing you individually? Am I representing this company that you're going to form? Or they're already formed a company and now they've got issues. Who am I dealing with?
Yeah. So have you had to address that in an engagement agreement? And what did it say?
Well, usually it would just say, I pretty much follow this outline you've got up here.
Yeah.
So it would say, you're engaging me to represent, Bob Smith or Bob Smith Inc. or whatever it is, and here's what I'm going to do. And if they say, well, we want to represent the two people who are forming the company or whatever, then you got a whole bunch of conflict waiver letters you got to send out too. Right. So you can say, by the way, you realize I'm representing both of you right now. Everyone's all hugs and kisses, but the reason you're doing this deal is because you got a plan for the divorce.
What kind of law do you practice?
I do business formation, I represent small businesses. I also do litigation. Mm-hmm. So I'll do like products liability litigation and things like that.
Let me throw out a situation that comes up in my world, which is all in litigation. I do predominantly products liability defense. Very often, I am responsible for defending a company at deposition, and that's my client. And lo and behold, we have an employee who's a former employee. Technically no longer falls under my umbrella of representation. But of course, you know, you have that last minute, oh, will you represent me at the deposition too? Which may or may not fall within the context of your representation, depending on what the person may or may not say. But how often does that actually happen in other situations? Oh, I'm representing this witness for today's deposition. And I wonder always, do you get an actual agreement for the representation at the deposition for that one time, whether it's free or not? Do you need one of those?
You don't do that. Do
Yeah.
you do that?
We don't. We haven't
Never
done that. And I think it may come down to the issue of the $1,000, depending on, you know, how long it is the representation or not. But it's crossed my mind. Boy, every time that I stick my neck out and say, oh yeah, I'm representing this person too, did I need an attorney, an actual written agreement?
They're not paying.
They're what?
They're not paying.
That's correct.
So.
But if you have them
But
to pull you out in the
client
hall,
is, yeah.
But have you had them to pull you out in the hall and say, hey, there's something I got to tell you.
Yeah.
And my boss doesn't know this.
But wouldn't you want that agreement anyway, just to sort of set the limits of this? Is it only for the deposition, or is it like tomorrow too? And what if there's a question later about it?
Yeah.
Where does it stop? So even though it's maybe an administrative time suck, and it always happens at the last minute,
right?
You almost want to have it in your briefcase without saying, here's
great
the deal,
idea.
right?
That just feeds right into my whole marketing idea.
Well, I think you might, and honestly, in going through all these things, I think I've found some things that are not very good about our large firms, you know, engagement agreement. One of them being, you know, one of the requirements under those code sections is that, you know, it's a memorandum or letter signed by the attorney and the client. I don't think we ever sign it. So if anyone ever took us to task, we just have the client sign off on it and return it to us. We don't. I've never signed an agreement. So I don't know, would we not?
Yeah, I thought
change your form.
I thought everything.
Yeah, I know. So at least in California anyway, because I mean it's maybe a form that somebody in New York put together. But you would, I don't know, you would just assume that a large firm has thought about that, but I don't know. And another thing that I think we as a firm don't do very well is, you know, so number 2 on the list is to really define the scope of the engagement that you're entering into with a client. So if you're being hired by, you know, X company to handle an EEOC charge, spell that out. If you're being hired to handle, you know, wage and hour litigation claim, spell that out. That doesn't mean that every single other thing that comes in the company's door you're going to be responsible for. And one of the things that we tend to do is we do these really broad agreements that just say, you know, we'll handle all employment law matters for you. or a lot of times you'll get the first case from a client and it'll be really specific, but then when you open the next case and the case after that, we tend not to do a separate engagement agreement for each case, and I think you probably need to. So when you know, down the road, when you have a dispute over fees, and you've got a contract to have handled a EEOC litigation, and a dispute came up in the class action case that they hired you to do down the road, you don't have an agreement. There's no contract, and they can say whatever they want to say. So things to think about.
So I actually am thinking about this a little bit, and I have a lot of landlords who hire me sort of for general advice and counsel. And they call me so that they can call me and ask a question. So, you know, in a month I might bill them for 20 minutes. So it's under the $1,000, but this goes on forever. You know, I mean, do I need a contract?
Gosh, probably. I mean, you probably will be best served to have one, right?
Right. Well, and so I do. I have sort of a general advice and counsel regarding these matters, like general matters, but that's awfully broad. But
yeah. But then when that client comes to you with a specific case, do you have a separate agreement? Yeah. See, that's where I think we fail. Is in the follow-up agreement. Well, terms of payment, that's probably the most, the most obvious one, and the one that we're all probably the most focused on in putting agreements together for people. How much is the billable hour? Who's going to pay for costs? Are we going to front costs of the litigation? Are you going to reimburse us on a monthly basis? How's that all going to work? At the, when the rubber hits the road, those are the things you're really going to want to have spelled out very specifically. An increasing number of clients are requiring budgets at the outset of a litigation, and they want to know, are you sticking to your budget? Is that going to be part of your agreement? Do you guys put? Do you have?
I have. Yeah, we're going to talk about budgets in a little bit.
Okay. In terms of billing at hourly rates, one of the things our agreement says is we reserve the right to increase our fees on a regular basis, and we will, and it'll be reflected on your next bill. I don't know if that's being very specific. I don't know if we've been tested on that, but it's that's what we say, and that's how we do it. Another thing that clients really want to know is staffing. Who's going to work on my case? I hired you, and then I'm looking at your bill, and you had an associate I've never met who's done 90% of the work. So, and clients get really disappointed about that. So you want to set expectations right up front. Here's who's going to work on our case. That can even link into to fees in terms of another thing our agreement says is the fees that everyone in the firm range from $200 to X dollars, and these are the people that could help me, and we reserve the right to staff the case as we see fit. Communication. What can the client expect in terms of communication by the attorney? How often are you going to give them updates? How are you going to do it? Are you going to give them telephone calls? Are you going to text with them? Are you going to send them emails every week telling them how their case is going? Yeah.
Is your contract, for an example, is your contract really that specific as to where we will call you every week, or we will email you an update monthly?
No, actually reading ours, what ours says is just what the client is supposed to do for us. You will communicate with us regularly. You will answer phone calls. You will give us documents when you request them. If you don't, it's going to impact our ability to represent you, and but yeah, I noticed there's nothing in there about how we're going to communicate with them. Well, how about you? I mean, what did you say?
I mean, the standard for mine is that I think it's I believe best efforts to keep you informed of all pertinent legal developments or something like that in your case.
Yeah, I think increasingly, I mean, it's all email, right? I mean, in terms of how you communicate with clients. I have some that we end up texting. I don't like that so much. But yeah, and I don't know that you need to be that specific, but in terms of whatever you guys sit down and decide on, that's going to be the expectation, and that's going to be something at the end of the day when they don't want to pay your bill. It's going to be something they're claiming. You did a lousy job, and I didn't hear from you for 2 months when all this discovery was due, right? I think you want to have something in the engagement agreement about what's going to happen if a conflict arises. And then that almost brings up the issue of conflict waiver letters, which are kind of like a sub-engagement agreement between, because another thing we're always real clear about is we represent the company, and X manager was sued too, and we don't think there's a conflict right now, but if one arises, we want to make it real clear we're representing the company, and we're not going to be able to continue representing Joe manager. And everyone usually signs off on that because Joe manager is getting his bills paid for him. And I've never really seen that called into question, but has anyone? Have you ever had a conflict waiver challenged?
Not challenged, no.
Mm-hmm. And then the thing to keep in mind at the end of the day with respect to engagement agreements, when the rubber hits the road, when the client says they're not going to pay, and you end up in, say, arbitration, which we're going to talk about a little bit later, the contract's going to be interpreted from the perspective of a reasonable client. It's not going to be interpreted from what an attorney would expect with respect to an engagement agreement. It's going to be interpreted strictly as what would a client expect, and anything that's the contract's silent on, probably whatever the client says it should say, or says that you represented to them, is probably how it's going to be interpreted. So other things to consider, I came up with the idea of, alternative fee arrangements and how those could get spelled out into engagement agreements. Does anybody use alternative fee arrangements, which I guess would be anything other than a billable hour or a contingency?
Flat fees.
Flat fees.
Flat fees.
Paid statutory fees.
Mm-hmm.
Yeah. What kind of law do you do?
Mainly estate planning and the occasional probate.
Yeah.
I do like a task where for certain clients, I do a job for X amount of dollars, and I'm how long it takes me, and they get a schedule that ahead.
Yeah. Is that an insurance company's idea?
No, I do a lot of work for financial institutions.
Yeah, that's a direction things are going for sure. Is flat fees. Passing overhead charges onto clients, which is kind of a gray area. It could be telephone calls or photocopies, things that you could argue are costs associated with the case versus salaries of your staff, overtime charges incurred. The general rule is you can contract to pass these costs along to the client, but it's got to be in writing. Costs directly associated with the litigation are fine. I don't think you're going to get any client these days that's going to let you pass office expenses along to them. I worked for a guy when I first started practicing, and what he would do is bill all of the secretaries as paralegals for any piece of paper they touched. Writing letters, and it didn't even seem right to me at the time. But yeah, every time you print a letter, bill point 2 and say, I handle correspondence between so-and-so and so-and-so. That was his answer to that. He tried to make it a legal charge. Ethically, I don't think that's proper. But in terms of, the other things you want to really spell out in your engagement agreement are some costs you can pass on, filing fees and photocopies and all those things. Are you going to advance all that? Are you going to advance it up to a certain amount? Are you going to send invoices to the client to pay directly? Those are not conversations you're going to want to have with them down the road. Financial management?
One question
Yeah.
before we go on about this. So I recently decided I should add, when it came up when a client asked me about this, a disclosure about cloud computing. So for example, my billing software is online. So, there's a possibility that that software could be breached and that now confidential information has been released. Is there any obligation to disclose this? And is there a best practice?
Alva Harding, if you had come to the Law Practice Management Series #2, you would have known the answer to those questions. I know. It was a phenomenal program, and yes, the issue is there are issues, and there are client confidentiality issues. In fact, when you mentioned communication by email, the first thing that came to mind is what we learned there, which is don't communicate with people that are using Gmail. It's not secure. You cannot have client communications with Gmail accounts. So it was really very interesting. But yes.
No, I think what they said was that we put it in your contract that communication by, I actually say, mobile phones and email are not secure, and client agrees that they can be communicated with by mobile phone and email. So they're waiving the lack of security in your fee contract.
I agree, but I still don't think that gets over our ethical obligation not to use an unsecure.
But the client's using Gmail, I'm not.
Exactly,
The client's sending me an email from their Gmail account, and I'm going to say, you can't communicate with me because you have Gmail?
And I have clients that insist on sending their through Google Docs. And they will not take no for an answer. They literally will not take no.
Well, the short answer is probably to put in your engagement agreement that they're taking responsibility for any breach that would.
I think that's the best you can do, right? Because even if you refuse to communicate with them, they're probably going to email you anyway, right? And you're going to sort of lose.
We have it. I don't encounter this a lot personally, but I've heard a lot. A lot of big companies that you do work for increasingly come to you and want to know, what are you doing to protect all the information we give you? So a company is going to let you handle 500 EEOC charges for them. They want to come in and they want to inspect the mainframe, all of the security and encryption devices you've got, and it's so if you're going to do business with Walmarts, and it's very onerous, and it's not something you're going to bring to them. It's something they're going to come to you and say, you're doing this, or you're not going to get our business.
You had a question there, and then we're going to move on.
One is on the Gmail. The other thing they brought up was that you may be waiving the attorney-client privilege because of that. So the other question I had was, what do you do if you have a client that won't sign a fee agreement?
You can.
I've had all the years I've never had till about 2 months ago. The guy came up, he was referred by another attorney. I did a bunch of work. He was kind of in a hurry. It was way over $1,000. And he came down, he said, I don't want to sign a fee agreement. I don't believe in him.
Now you got a statute you can point to.
Yeah.
I have to. You have to.
You have to.
And I think malpractice, a lot of insurance carriers require it to have one, right?
Yeah. Yeah. All right, so we're going to move on now from the engagement relationship into what I call in this part the financial management of client funds. And we're going to talk a little bit, just to start, about the obvious things having to do with the type of agreement that you have for how you're going to be paid, and the trust account, and all of those things, and your obligations to keep records. But then I wanted us to think about this more in the business context, and what financial management of the client relationship can also encompass. And this is where we're going to talk about all of the other things that are money that are involved in the handling of a client's case. Okay? So first of all, let's move on, and I think this is probably everybody knows about this, and it's good to review it, because you would be amazed when you pick up your State Bar Journal how many attorneys are disciplined, suspended, or disbarred, right? Because they have not followed rules of professional conduct 4-100, which simply says that you must keep client funds in a separate account, and you must be able to account where the money comes from and where the money goes. And then we'll talk about some rules that the Board of Governors also have adopted that tell us what that requires of us. But you know that you must have a separate account that is maintained with the client funds, okay? And depending on whether an engagement involves a pure retainer, in other words, a client is paying you an amount of money simply to be on call, and that money is yours, or you have a different type of a relationship where they are advancing your retainer. In other words, you're billing against the money that's deposited, okay? You still have an obligation to keep track of those funds in a separate account. Okay, and then the commingling, you can't borrow from your trust account. You know that. You can't borrow it and repay it. That is not something that you should be doing, and you should not be putting firm monies into your trust account under any circumstances.
Not even to buy a boat.
Not even to buy a boat. Okay, so in 4-100, in the very last subsection of that about preserving the identity of client funds, the legislature says that the Board of Governors is given discretion to tell us lawyers what records we have to keep. And so the Board of Governors did come up with rules and regulations about what that is, and they went into effect January 1 of 1993. And you know what? It's a lot. Okay, we have a lot of obligations to as a lawyer to keep track of the funds. Okay? If you have good accounting principles and practices in your firm, this is a no-brainer. But sometimes maybe we're starting new accounts, maybe we're starting firms, we're setting up new accounts, and maybe you aren't dotting the I's and crossing all the T's. But basically, these are some of the requirements, and it's not insignificant in terms of what you need to do. I'm not going to go into them in a lot of detail. They're there. Know that they're there, and reflect upon them, and make sure your protocols in your office follow them. Yes?
Question. I don't. It might just be my personality, but I've had challenges over the years finding bookkeepers, CPAs, who are up to speed on the type of accounting that goes on in law firms, such as trust accounting, client funds, and things like that. Is that a normal situation out there in the trade marketplace?
I have not found any difficulty at all. Either with banking institutions that I've done business with, they all know what a trust account is. And the reason that they know that is they're actually regulated to report to the state bar if a check is ever presented on a trust account that has insufficient funds. So even if it's paid, let's say there's overdraft, if there's insufficient funds without the overdraft, the state bar finds out about it. So I think the banking institutions do generally know about it.
Well, I wasn't talking about the banks.
Yeah.
But I have seen that some of the banks have had problems. Some of the listservs I'm on, people have had trouble with their particular bank. I was talking about staffing, office staffing for this kind of technical, law-oriented accounting. And I would appreciate some suggestions as to where you find such people.
Jim, I can give you some things.
Yeah, that, and we go through training. I mean, because anybody who's going to have any the ability to deposit or write checks on or keep track of the ledger for my trust account is going to go through a rigorous training with me personally, with the rules in front of us. Because I do think we have an obligation to make sure that the people that work for us know what the rules are. And I think it's an investment on our part. I like it when someone comes to me and they have that experience, but if they don't, it's up to us to do that. So, all right, we're going to talk about a few issues that are, bigger ideas. We already basically talked about true retainers, security retainers, and this advanced payment retainers. But I want to talk about other financial relationships and communications that we have to have with our clients that, at least in my world, are coming up more and more. And this has to do, we talked about legal budgeting. Very few of the corporations that I work for, and even some individuals, are asking for a budget, okay, of what it is going to cost them to handle the matter that we have been engaged for. And so I think we have an obligation, if our client asks for that, to provide our best estimate of what services and the costs that are going to be associated with a particular legal matter. I, of course, tell everyone that this is my best guesstimate. And depending on how far out you want me to go in my legal budgeting, it becomes more of a guesstimate. So I actually had a client, if you can believe this, that required a litigation budget through trial within 5 days of a case coming in the office. 5 days. I mean, really, all I had, maybe I had an accident report, and maybe I had a complaint. Okay? It was totally impractical. And I actually told them repeatedly, this is really not a good idea. You really might consider doing phased budget work, like how long will it take to get into ADR, or into, do some initial discovery, and then look at where you're at. This looks like a case. I've handled half a dozen of these cases. We usually do summary judgment, so this is another phase. And it can be much more realistic, because the problem is if you're asked to give estimates about something, all you can do is say, well, generally speaking, these cases range from this amount of fees to this amount of fees. This one was a good deal, that one was the nightmare case. And it just isn't really practical. So I encourage my clients to actually do budgeting in phases. But I want them to know as soon as possible how much it's really going to cost them and why. Because a lot of our clients are business people. and they are making business decisions that have to do with the payments of money. And what that means is if you give them a reasonable estimate about how much something's going to cost, they can make a business decision. They're educated, can make a business decision about whether or not they want to resolve it for a lesser amount, another amount, or handle the case in some other manner. So I think it's it's a whole nother area of financial management that is happening, at least I'm seeing.
So budgeting too, there's clients wanting budgets, but our firm is increasingly, if you have a litigation matter, they require a budget, and someone tracks how you're operating to budget, and they use those numbers to see how efficient everyone is. And I actually was thinking that because I have an email right here from matterbudgettracking@littler.com that says, "Hello, you are receiving this email because you are the attorney on a litigation matter that's been open for 45 days without a budget. Please upload that to the..." Frankly, takes all the fun out of being a lawyer, but yeah, that's where it's going.
Yeah, hand in hand with that, quarterly we do actual versus budget. For every matter that we have a budget so we can see what we're doing. We also implement kind of like that, depending on how big your matter is. It could be a $1,000 bill, a $5,000 or a $50,000 bill when you come within budget, so that you know, we're coming close. What happened in the case that was different? Do we need to revise our budget and update our budget so our client knows when we get to the next billing cycle what's going to happen? Other things seem to be really upsetting to my clients, because oftentimes they don't know is all of that things like expert fees and litigation costs, because they're very, very expensive, as you know. And so often making sure that they know and know up front, this is the kind of case that might scream for this kind of expert. And the last 10 cases I had, this is generally what the fees were for that expert. Okay, and having that dialogue with them, not just as a statement in your engagement or agreement that they have to pay for experts, but that this is what it is, and this is what it's going to do for you, and this is how much it's going to cost. Similarly, I don't know if you're noticing it, but vendor and court fees have skyrocketed. Most recently, I think it was in Alameda County. Did you hear this? $60 per motion in limine. $60 per motion in limine. I don't know about you folks, but I routinely get about 20 motions in limine in big litigated cases. Okay, that's a lot of dough. And that's nothing we have control over. And so again, as part of our relationship with our clients, I think we need to tell them that. I have to tell my client, I have to file or pay $150 at the first case management conference now if you want a jury. And I'm sorry, I really don't know if you can waive one yet. It's so early and it's non-refundable. And the more that you educate and you work with them and communicate all of these costs, I think you're doing your client a service in terms of that financial management relationship that we owe them. All right. What financial obligations do we have with our clients upon termination of the engagement? One of the things we're going to talk about at length today is termination of the relationship, how to do it, what are the consequences of it, both ethically and from the management of the client. I wanted to point out here in context of the financial management of the client, simply that when that engagement is terminated, we have an obligation under the rules of professional conduct to promptly refund any part of the fee. Okay? It doesn't get to sit there. It doesn't get to pay. You have to turn it over and do it quickly. Now, this is the rub. What about lost my train of thought in terms of the promptly paying on termination. There could still be outstanding costs. There could still be things that may be owed. And that's, how far can you hold it? How far can you hang on to that money before you have to turn it over? And that's a difficult question, but we're obligated to turn it over promptly. All right. That's financial management issues. I want to move now to something very near and dear to my heart, which is billing. And I always start any talk on billing on what I tell our associates that I think are billing entries. I don't know about you guys, but it's probably the most important piece of legal writing that I do on a daily basis. And the reason for that is, one, if I wasn't under the constraints of myriad billing guidelines or uniform task billing codes, I would be able to describe what I did to a T to my client. I could explain all the fine legal work and value that I did and the fee that was associated with it. And that's great, but I don't have many clients like that anymore, because most of my clients are ones that are either electronic billing clients where you have codes and you have 250 character restrictions, and you literally have 5 categories of things. I mean, we've been reduced as lawyers to 5 categories of value to our clients. Appear for, attend, plan and prepare for, draft, revise, review, analyze. There's one more and I'm missing it, but that's it. Everything I do as a lawyer that is billable in my clients, many of my clients' mind is reduced to that. So that makes it extra challenging. And it's time consuming. I mean, everybody goes home at night and hasn't finished their time entries, right? It's hard. It's time consuming to keep track of what you do when you've got 20 things that are going on at once. And it's very, very regulated, which gets us back to that constant reminder that we have obligations under the rules of professional conduct to do our billing in a certain way. So it's all of those issues tied up together that really, really interests me. So I want to start with one of the basics. And again, this is something we all know. It's not, you can never hear it enough, which has to do with how much can we charge our clients, all right? We are regulated in that respect, right? We cannot charge a fee that is illegal, of course, or unconscionable. And there is so much definition of factors that go into what's an unconscionable fee, and all of the cases and opinions that have been written about this and what is and what isn't is amazing. But basically, there are in the rules of professional conduct this is in 4-200, 11 categories or factors, if you will, of what makes a fee conscionable or unconscionable. I don't intend to go into great detail again here. My point is, I want you to know that this is the umbrella under which everything else we do is going to be judged, is in the end whether or not the fee is reasonable or not. Okay. We are, as you know, this is in the Business and Professions Code section, which governs our billing. There's nothing per se in the rules of professional conduct about the details of the billing. But so we're looking now in Business and Professions Code section 6148. And this is telling us what we must communicate to our clients in the billing statements, all right? So you have to clearly state what it is you did for your client, all right? Your bills must reflect, obviously, how much time was spent, the rate, and then how much the total service was, for the value, all right? Bills for services must be separate from charges for costs, okay? And the costs similarly must be described so that the client knows what he, she, or it is paying for. Now, I don't know how many of you have to deal with this, but if your client makes a request to you for a bill, you have an obligation to produce that bill within 10 days. All right, and let's say you have one of those crazy clients who's asking you constantly for a bill. Well, you have a little bit of a reprieve, because if they've asked for it in 30 days, you get a 30-day reprieve, and they renew it the next month. But if a client asks for a bill or how much in services have been rendered to date, you're obligated to give that information to them. All right. I want to take these rules and think about it in the business management context, because some of this stuff comes up with me on a regular basis. So, billing programs. You know, there's a number of billing programs that are on the market that you can use to generate your bills, and it seems like none of them are exactly what my client asks for. And so we have to modify them, or you have to, you know, have a client-driven billing program that you're using. And you must work within the confines of the Business and Profession Code's obligation to make sure that whatever billing program you're using, even if it's your client's, that it is actually, it conforms with the law. We've talked a little bit about the Uniform Task Billing Codes. Does everybody know what those are? Yeah? Okay.
I don't.
Okay, so what it is the ABA came up with some uniform codes that were to be used for legal services. And we define them as, there's L codes and there's A codes. And the L codes are the legal, the legal task, if you will. And then the A codes are the activity codes, and that's what you did. So, and what it basically means is that every legal service can be broken down into kind of investigation and file handling, pleadings and motion work, including dispositive motions, discovery, which includes depositions, trials, and then the final category, the 500 series, is the appellate issues. And so within the context of, I think it's 25 total legal tasks, you're supposed to fit what you did for your client within them. And then you further get limitation in terms of what it is and how you bill. And so you are constantly challenged to make sure that you are describing the services that you're required to under the ethical rules within the context of the Uniform Task Billing Codes. All right, let's talk about block billing, because this is a situation that actually came up with a colleague of mine down in San Diego.
You know, before you even go by, we may be short on time, sorry, but before you even go past billing programs, so we use billing programs and we have protocols that we're required to follow. But the clients and the more sophisticated clients know that, and there is an industry where someone is making money having programs that dissect our bills and go through them line by line and find reasons why the client does not have to pay them. And the client hides behind it as a shield. I don't know if you've ever gone through is anyone familiar with the Serengeti tracker system? You have clients that use that. There's a few others, like I know Farmers Insurance has one. But it's a way that the client can wipe its hands clean of the fact that it's not paying you. But they've hired a service to go in and find everything you've done wrong. So this is...
We have a full-time person at our firm who actually makes sure that our bills pass muster before they're sent. That's the goal, and then appeals anything that seems appealable after. It's amazing what that's taken on. Okay, so let's talk about block billing, because when I started as a lawyer a long, long time ago, the bills were prepare this period, then meeting with client period, begin preparation of motion for summary judgment period, all in one single entry and one single amount of time for the whole day. All right, that's called traditionally block billing. Well, I think some of the objections started, I remember back in the probably late 80s, early 90s, where insurance companies in particular objected to block billing because they couldn't see and they couldn't track what you were doing, and they couldn't use those kind of statistics and metrics to compare your performance and your services against other firms. And so they objected to block billing. And so what came out of that was another form of block billing that attempted to address that. For example, meeting with client 1.2, attend site inspection 2.4, all in one block. So that there were segmented breakdown of time for what you did in a day, but it was still in a single block. The billing charge was what was billed for the day, and then there was a total amount of money that was billed. Okay, everyone think that's okay? Well, I don't think it is okay anymore. And I want to talk about the situation that happened with a colleague of mine. So she was in a fee dispute with a client and they went to an arbitration, but they ended up doing some informal discussions, and ultimately it worked its way into a decision. But what happened is that the client said, you are not following the rules of professional conduct and the Business and Professions Code because you are not making it exactly clear how much you are charging me for that specific task. It's not clear on your bills. And then my friend said, what are you talking about? It says at 0.5 here for this, and you can see that my hourly rate is this, and if you took your calculator and you went this time this, that's how much it cost you. Well, the arbitrator actually said, no, I'm sorry, the client should not have to do that. The client should be able to see the amount of work that was done, the actual time entry, and the dollar value for that specific in clear terms. And what happened? And what are you seeing more and more of? Single line entries. Okay? So on a given day, you could have 5, 10, 15 entries with a single billable amount. Why would you do this? Okay, nobody likes it. It's time consuming, it's another entry. But if you get into a fee dispute, are you the firm that wants to be the one defending your block billing, even if it's got task time? I don't, and so we've changed. Now, we had one attorney that was a holdup, and he actually took advantage of one of the exceptions in the Business and Profession Code, which basically says that you can, with written consent to your client, have a different billing arrangement so that they don't need it, spelled out and spoon-fed. So that's just something to keep in mind in terms of your billing practices. I want to talk briefly about the ethical issues involved with timely billing. Okay, timely billing is probably the bane of my existence. Not only my own, I mean, come on. But it's everyone else in my firm. I've got to make sure that all of the attorneys and all of my timekeepers, paralegals, whoever, are billing on a timely basis. Why? Because is it an accurate and ethical reflection of time spent if you are not entering your time for a task until the end of the month? Can you really say that it took that much time with any degree of confidence? I'm convinced, by the way, that the client wins every time. Okay? I don't think we bill efficiently when we do that. But forget that for a second. I think the client could make a case that how could you possibly remember to the 10th of an hour whether or not you spent that time? And so there's a reason, an ethical reason, why we should be entering our time on a fairly regularly quick basis, separate and apart from the loss of time for all the things that you forget.
And without going into details, there are studies that confirm what you are saying. You lose an average of, I think it's 4 or 5 hours a month. I mean, they've done studies. So in the 8 years or 9 years, however long I've been at the firm, time was released every month and then every 2 weeks, and now every Monday night by 7 o'clock or get in trouble.
Yeah.
So
Perry and I had a real interesting discussion about this. We're not going to spend a lot of time because we have some other things to talk about. But what do you do with what I call the dilatory attorney? I don't care if it's a shareholder or it's an associate. The attorney who doesn't comply with your regulations, your firm policies about entering and posting your time. Okay, it's a tough situation. I actually defer to the employment lawyer on that, actually. But it creates a lot of problems, and it has been in every firm that I've seen. We've had those issues, and I don't know.
You know what the employment law firm does? It's public shaming. You end up on a list. You end up on a list that gets emailed out. It's terrible.
Yeah.
So.
Okay, and last point just to take with you. If you do not comply with the provisions of the Rules of Professional Conduct and the Business and Professions Code, and your billing is not up to snuff, the client can actually render the agreement voidable, and then you're probably trying to get quantum merit for the services that you perform, but you've lost your agreement. So, billing practices are very, very important. All right, we're going to move on to disengaging from representation as we move through the attorney-client relationship, and Harry's going to take over from here.
And in terms of disengaging from representation and the business issues that we're talking about today, really thinking of is disengaging from representation from the client who refuses to pay your bill. So there are the rules of professional conduct 3700 talk about there are reasons why you have to disengage from representation. Your client's up to no good. Someone in the firm's gotten involved in a romantic relationship. Actual conflict of interest arises. A lot of things that you're familiar with. It's 3700C that has a list of reasons why permissive reasons why you may withdraw from representation. And it's 3700C F that allows an attorney to disengage from representation from the client who breaches contractual obligation. Back to the engagement agreement. The contract we're talking about would be their agreement to pay your fees. And actually, I actually didn't know anything about this until last year when I think we filed 4 of these. But have you guys ever filed this motion to be relieved as counsel of record? Yeah? Client not pay your fees?
Client non-cooperation, not paying fees, approaching trial, big mess.
Yeah.
This was a while ago in a different life. So I wasn't doing special ed law at the time. I was doing insurance defense.
Yeah. So it's actually mandatory that when you so first thing you want to try to do is find another attorney for your client. You want to try to substitute out. Sometimes, and I find this amazing that when you communicate to a client, you do not want to work for them anymore. They still want you to work for them. It's incredible. That would happen more often than you think. It happened a few times in one What the rules say is there's a mandatory form that's used, and this is it. Notice of motion and a declaration that goes along with it. So in state court, you simply you get a hearing date. You basically put the declaration. Here's what I did to try to find them a new attorney, and here's what they did to warrant me withdrawing. And there's ethical considerations because you can't throw a client under the bus. You can't subject them to prejudice. But all you put in here really is that the client breached a written agreement with you. And if the court wants to know more at the hearing, they can request, when you show up to the hearing, you should bring evidence. You can go back in the judge's chambers and you can do an in-camera review. But these will more often than not be an unopposed motion that you file because the client doesn't do anything about it, and the court will let you out. Similarly, you do the same thing. We've done the same thing in federal court. You just have to actually put it on pleading paper, but it's the exact same thing. It's just a motion. Here's the professional rule of conduct. Here's why the client breached, etc. So. The real thing to keep in mind is that you're doing your declaration in very general terms because it is still your client. So you can't say things in your declaration like, I know this client has the money. I've seen their bank account. I know they have the money, but they refuse to pay me. You can't say they're broke because you're going to prejudice some, because you're filing something that's getting filed in the public record, right? Yeah, so that's the rule. Anybody have any good stories about filing any of these? Hopefully you never have to. Yeah?
I have to file one because I couldn't find the client. So a day or two after was granted, the client showed up.
Yeah. Yeah, we had another one, big client that was headquartered in Ohio, and they just ignored everything. And it was a couple of really big cases, and then one of them, the day of the hearing, we got another firm substituted in. But that's when we finally got their attention. And another one we filed, and then the client paid and begged us to keep representing them. So
I think it's hard, again, putting on your business business management hat, it's obviously hard to know when you got to go in and ask to be relieved. You've invested time in it, sometimes money, and if possible, you'd like to salvage the relationship and be paid for your services. And so it's a fine line. How long do you keep bugging the client about paying, reminding the client that this is what their agreement was, that you cannot continue the representation before you actually go in and file the motion. And I will tell you, the longer that I've practiced law, that is a lot. That little leash has gotten a lot shorter over the years, because it's a financial tolerance issue. And I think I'm much more willing to go to a client and say, I fire you, basically. I don't want to work for you anymore. And that's a luxury, I think. But it's easier to do now than it was before. Before I believed in the good faith of the client and the ability to pay, and yeah, we're getting in this together. And now it's like, this is a business. I wouldn't come and ask you to provide your professional services for free, and I don't think you should expect that of me. So,
where this came up in another situation is we had another. It was a client that was it was the client of one of our attorneys in Walnut Creek. He had sent a case down into Los Angeles, and someone in Los Angeles was handling this case. Their relationship with the client became toxic. There was bad communication on both sides. That they refused to pay bills. The firm, meanwhile, we were handling 2 cases up north. Everything was fine. They were paying our bills. The firm made a decision that the relationship with the client was toxic, and we were going to withdraw from representation in every case that we were handling for them. But us two in Walnut Creek thought, how am I going to file this motion? They've actually paid all of our bills. They're current. In fact, it was covered by insurance. They were paying all our bills. But the firm's take on it was, and they had half a dozen people weigh in on this, was that if the client is not paying fees, it's in breach of its obligations to the firm as a whole, so we withdrew from representation. But I actually was not comfortable with that decision.
this is a kind of a good lead-in, since we're terminating a relationship, an attorney-client relationship, both in that situation and in the successful and the successful conclusion of a case or a matter, and the shake hands and we'll see it to the next time. What do you do with the files? Okay, and this is something I don't have an infinite amount of space in my garage, so I end up paying storage fees to a facility to maintain client files, and it's that dilemma that I want to talk a little bit about and think about, okay? But first of all, let's talk in follow-up to what Harry was talking about. Let's just say that a member whose employment has terminated, okay? So the attorney-client relationship has been terminated, whether it's because the client has said, I'd like to substitute in a new attorney, or you are going into court and being relieved of your obligations. Okay, what are we obligated to do under the rules of professional conduct with respect to all of those files? The reports, or the deposition transcripts, or the expert reports, things that have gone on in the litigation. Paid for or not, by the way. Think about that. We have an obligation to turn over the files of the matter to the client promptly, okay? And the client papers and property is big and it's broad, all right? Look at what it includes. Correspondence, okay? That would be any correspondence with the client, third parties, right? Pleadings, transcripts, exhibits, physical evidence, expert reports, anything else that was reasonably necessary for the client's representation. Guess what? And you have to do it even if the client hasn't paid for it. So there's a deposition that you have in your file, but the bill hasn't been paid. You've got to turn that deposition over to the client. It doesn't seem fair, but that's what we're obligated to do. Okay?
Question.
Yes.
What about emails? What about your notes, your own personal notes? What about your binder that has all of their massive documents organized?
I think you have to turn it over. And the reason that I say that is because your notes about the file reflect the strategy and the representation of the client. The client paid for that, right? Well, maybe they didn't, but it is part of their representation. If you undertook the effort for it, I do think you have to turn it over. I think emails are, in this day and age, included as part of any correspondence or written communication. It's just, we bill for it. It is a communication that has information relevant to the relationship, and I actually think it has to be turned over. Now,
we file internal emails separately and do not turn them over.
Internal?
Any internal emails.
Yeah, I don't
anything
keep
that's
those
client,
in the file.
Attorney notes, memos, that kind of things, we keep.
Oh, well, okay. So you can, and we always talk about this, when you turn over the file, if I turn it all over and then they sue me, how am I going to defend myself, right? So you're entitled to, let me move this along, you are entitled to make a copy of that file, but it's at your expense, okay? It's gotten a lot easier this day and age with everything being electronic, everything being digital, and you can run a disk very quickly and download a lot of the work, but some of it has to be done by hand. But you are entitled to it, and I actually recommend, before I turn a file over, that we keep anything that we don't already have on electronic form, because you just never know. If a relationship is terminating for one reason or another, someone's not happy, okay? And so it's just a matter of, well, I'd rather have everything about the handling of this matter available. So, but you are entitled to do that. All right. Here's a couple of issues that keep coming up. I mentioned that it's costly to store files. Okay, so I came from a firm and was trained in this firm. We kept everything. When a case was closed, we made sure we had our endorsed dismissal, we had the signed release, and we had the final payment of our services, and we boxed it up in banker's boxes, and we put them in an old storage room until we couldn't fit anything more, and then the truck came and took it down to the storage facility, okay? And then 10 years later, when we needed a file, oh, we knew something, we pulled our files from storage and we got it, okay? It's expensive. It's very, very expensive to keep your files in that way, all right? And then, as I found out in my own firm now, because I don't want to keep them so long, it's very, very expensive to destroy files. Okay, you have to pay a lot of money to ask that storage company to actually take your boxes and destroy them. So it's an expensive proposition. And I am actually, I have talked to a lot of people about this and said, what's the solution? What's the solution to this? And several attorneys that I know have suggested, well, put it in your engagement agreement, what you're going to do with the files when they're done. Okay, so if I know that 3/4 of my case is on my system and it's on my server and it's backed up and whatnot, I've got a good part of their file, and anything else I can either copy in electronic form. I can actually keep as much of that file as I want, and I can put in my engagement agreement, client, we're going to give you 3 months to collect your file, and then we're going to get rid of it. Okay? And we want them to know up front what we're going to do with your files. They have the option of keeping the file and getting it and taking it off your hands, or you're going to destroy it. And it's a lot cheaper for you to destroy it rather than sending it to a facility. And then there's also the option that you can go ahead and digitally scan. If you aren't doing this already, your files, a lot of firms, bigger firms, are actually scanning every piece of paper that comes in. If you've already got it stored, what do you need the hard copy for? So I think it's something to think about in terms of how you're handling it. Is anybody else handling it differently or more creatively?
Well, other than stuff I'm required to keep originals for, so for each file I have a little thing that says the name of the case and original document. So if I send out discovery or something like that, right, I got to keep the original stuff. Every piece of paper that comes in, I scan it and throw it away.
Yeah.
Mail, pleading, anything I don't need the original of, I scan it and throw it away.
Yeah.
Now, I came from my own firm, so I still have several file cabinets full of stuff from my old firm that kept it on paper. But to the extent it's all new stuff for me, it's all scanned and thrown away, and some of the stuff was scanned by my old firm, so I still have it. And I gotta figure out what I'm gonna do with some of my old firm files that are all paper, and if I want to pay to have them scanned or just throw them away.
But now if someone asks for a file, you just give them a CD?
If someone wants a file, yeah, I'll just give them a CD or flash drive.
That's what I do too, yeah.
You know, I don't have any litigation files from clients who are individuals who want it back. The litigation files are all kind of big companies who want me to store it. And I'm like, I don't want to store this, so I'm going to come up with a way to not store it. Because like you said, it's expensive and it's time consuming and it takes a lot of space.
Right.
In terms of files, I mean, pleadings with court are paper and notes you scratch down are paper, but it's all email. Everything is all, it's almost all electronic now.
Well, everything I do is I keep electronically, so I can just, if I don't have to keep the original, even if it's at my sign and the original gets mailed off, then I've got a scanned copy of the one I sent them. Yeah. That's my copy.
You had a question, I think, or a comment?
Yeah, I've got files back from the 80s. When I started practicing. What knowledge do you have about the requirements to notify clients before you destroy documents?
Well, I don't think you have an obligation to tell them after so long of a period. The only thing you have to worry about is what you're required to keep and for how long. So we saw in one of the earlier sections that you actually have an obligation to keep for 5 years all of the financial management documentation having to do with client property, and whether that's funds or securities or actual property, that's a 5-year limit. Okay, so I actually, we have a policy, a record keeping, a document retention, client file retention policy in our firm, and it's only because we undertook keeping them and told them that we were keeping them in our engagement agreements. All the new ones have changed, but as to those, we told them that we would keep them for a period of 5 years from the dismissal of their action, except in cases where minors were involved, in which case it would be 2 years past the age of majority. There were a couple other nuanced cases that we would keep them for a longer period of time, but from our perspective, it was a 5-year obligation. And we felt that that was in conformity not only with the financial management requirements, but that was a pretty good time. Now, 5 years comes and we're trying to clean it out, and we get the bill about what it's going to cost us. I said, you know what, we might need that file someday. So we keep it a little bit longer. But yes?
So you don't have an obligation. I similarly have files going back to 1980s because I'm in estate planning and the clients live forever, right?
But not forever.
Well, not forever, but they'll die 10 minutes after I destroy their file. I'm convinced of that. But you don't have an obligation for an old and stale matter. You haven't heard from the client for 10 years, and there's no original documents. You don't have an obligation to notify them before you destroy the file?
Not that I know of, but I don't know what kind of litigation or what kind of a matter. There may be special rules peculiar to your practice.
Well, it's estate planning. If you have an original document, you either have to return it to the client or you have to lodge it. There's a registry with the state.
Right. Yeah, I don't think you have an obligation to notify. I don't know of anything
I looked this up recently because I had a client who I said, what are you going to do with these files? And keep them for as long as the state bar says you're supposed to keep them for. So I looked it up, and the answer was I could throw them away the minute the case is done if I want to. There's a few exceptions, but none of them applied to anything I was doing. Not what they were, but
right. With the exception of that financial management documents, you have to keep 5 years. But everything else, you do not have to keep them, and that's why I'm saying you can turn them over to the client. They can take it and throw it in the dumpster.
And there were a couple other exceptions. I know the lawyer who sits next to me, he cites the rule that says the client owns it, and he sends the file to the client at the end of the case.
Yeah, and
I never thought about this till today, but we contractually agree to keep them for 10 years after the case is done, and I don't know where that came from.
Yeah, and anyway, it's something to think about from a business management standpoint, how to rethink some of that expense and cost, and still maintain your ethical requirements.
I think it's really important if you're going to return the file to the client, and there's any sort of cross-threading with that client. Well, you should just do it anyway. List at least by categories what you're returning and specific items. I think it's great to give them all the discovery, all the depositions listed out.
Yeah.
Because then they can't come back and say, well, you didn't give me the deposition of Bob's.
Yeah. Unless you catch it.
Yeah, it takes a little time, but it's one of the CYA things.
It's a great idea too. Okay, so we're at the conclusion of our program today. Does anybody else have any questions or comments about this? It was intended to, and I really appreciate everybody's participation, it was intended to be, you know, thought-provoking in terms of how to manage your relationships. Yes?
Well, thankfully I haven't had to deal with it yet, but when you're trying to palm off a client that hasn't actually paid you or won't pay you or can't pay you, is there any kind of heads up that you should be giving the...
That's our timer. Go ahead.
That you should be giving the attorney that you're asking if they want to take this case from you? I mean, I know I am always just a little bit more cautious taking clients from other attorneys that have already done work on that because I'm worried that they're giving me a bad client. So is there any like rule of thumb for how much heads up you should give your colleague?
Well, I think I know there's probably some rules. If there is an attorney-client relationship or anticipation of one, the communications are confidential technically. So you have to watch that. Depending on whether or not the client is complicit with you finding another lawyer and may authorize you to tell something about the case. I just would be cautious about it, what you said. Okay, if there's no more questions, thank you for coming today.
Thank you.
Thank you very much.